So a lot of students ask me, what do you do when you have this very vague statute that you have, something like malice as a mens rea term, or worse yet, you have Pennsylvania's third-degree murder statute that actually says that murder in the third degree is something that just doesn't fit into any other category. I mean, the actual language says all other kinds of murder shall be murder in the third degree. What do you do with that? How do you go about plugging that into the exam? So I wanted to use that as an example. I'm going to share my screen with you. I'm going to put this on Charter Course so you'll have access to it. But I want you to take a look at this thing that will be on Charter Course. You can find it in the third degree murder node. And you can find this video, obviously, in the third degree murder node. So this is sort of a template for how to think about looking at a statute. So you start with the language of the statute and you see what you can extract from that language. So here we have something that seems like it's useless. All other kinds of murder shall be murder in the third degree. Is that in any way helpful? It turns out, yes, there are things you can gather from that. What do you know from that language? Well, you know that third degree murder, therefore, does not involve the elements of first or second degree murder, or it is distinguished from first and second degree murder. What's first degree murder? An intentional killing. So third degree murder would be a form of homicide, an unlawful killing that does not involve the intent to kill. What's second degree murder? An unlawful killing that occurs in the course of a felony. So this form of unlawful killing will be one that neither involves an intentional killing nor one that occurs during the course of a felony. All right, we've gotten something from this. One more thing we can learn from this statute. Third degree murder is murder. It's not manslaughter. So whatever manslaughter is, it's more serious than that. Now, it turns out that there's not a very good line. There's not a good line at all between third degree murder and involuntary manslaughter. But we do know that whatever third degree murder is, it's more serious than involuntary manslaughter. Okay, so that's how far that just the language of this very unavailing statute, we can get a long way just from that. All right, so now let's go to the cases, because that's where you go, even when you've got a very well-defined statute, to give you some guidance, but particularly when the language is not that great. So we now want to go to prior decisions of courts, precedent, and we want to know what we're looking for. So with any criminal conviction, there's going to be essentially a three-stage process you want to look at. You want to look at what the person was charged with. This is not part of the precedent, but you need to know what they were charged with, because that's where the whole process begins. You cannot be convicted of something more serious than you are charged with. That's why this is the cap. It can't go any higher than that. This is a decision by the prosecutor. The prosecutor has essentially unreviewable discretion to not charge someone of something that there's probable cause to support. So the prosecutor can go as high as the facts will allow, but absolutely does not have to, and has to explain to no one his or her decision not to do that. But that doesn't tell us anything. The fact the prosecutor charged first degree murder in one case and didn't do so in an identical case doesn't help us from a legal standpoint in any way. This is very much a political decision, unreviewable. Now, once we then have that, there are things that judges then do that are helpful to us. The judge will determine, as the trial is being conducted, what evidence is admissible. And the judge will do that by determining what the elements of the crime are and the definition of those elements. So certain evidence during the trial that gets admitted may turn on the judge's definition of the crime itself. Once the case is concluded and the judge is trying to determine how to instruct the jury, the judge will then have to determine two things. One, is the case sufficient to go to a jury? Is there sufficient evidence to convict of any crime? And if so, which ones? And then most importantly, the judge will have to instruct the jury on those crimes. So the judge's instruction will become a source of definition of law, as will the judge's determination that this is a sufficient basis for the conviction. And if there is a conviction, the appellate court will then review the determination by the trial judge in instructing the jury and in determining that there was in fact sufficient evidence for the conviction. So now you have basically three different ways that judicial precedent can inform our understanding of the definition of a crime. In the way that the jury is instructed on the definition of the crime, in the evidence that is allowed to support the conviction for the crime, and then whether the facts are sufficient to show this crime occurred. So we take those decisions and we extract from them ways to understand these vague statutes. So the first thing we're going to look for in our cases that are defining the substantive criminal law, we're going to look for any kind of language the court gives us that fleshes out the vague language of the statute. So in the case of Pennsylvania, where you simply have any other form of murder is third-degree murder, that tells us really nothing. So we're definitely looking for this interpretive clause. We are looking for additional language that a court will give us to understand what's meant by everything else. And so we have in the cases we've looked at this quote, the distinguishing characteristic of murder is malice aforethought, and that can be defined by any number of things: particular ill will, wickedness of disposition, hardness of heart, cruelty, recklessness of consequence. So that's language the court has added to what the legislature has given us. So now that we've got that, that's additional guidance for us to interpret this vague statute. So now we're going to want to look for some examples to flesh this thing out even further. And some examples and some factors that the court gives us or that we can extract from the facts. So when we look at the cases we've looked at that help us understand this, would first relate to first-degree murder, because we know it has to be something that doesn't yet arrive or doesn't arrive at the level of first-degree murder. So what exactly is first-degree murder? It's intent. How is intent defined? We look at the Elliott factors, and the Elliott factors we know are motive, planning, and the method of killing that would suggest the intent to kill. And as we know, Pennsylvania courts and California courts, for that matter, where the Elliott test was developed, do not require all three of those to show the intent to kill. But we look at those as a guide to determine whether the intent to kill has been satisfied. And so then we look at the specific facts of cases to determine whether the intent to kill has been satisfied. And we discover that something much less onerous is required of the prosecution to show the intent to kill. The method of killing can itself show the intent. Deadly weapon, protracted acts of killing, strangulation, for instance, drowning. And then the mere statement of intent, I'm going to kill you, can be sufficient. Even though we don't really think a whole lot can be, gleaned from that, particularly in the heat of combat. At least not a lot of protracted thinking. So if we don't have any evidence of intent to kill, we're now looking to try to define third-degree murder. And if there's no evidence of intent to kill, third-degree murder becomes kind of our presumptive landing point. So what can we glean from the case law about the definition of third-degree murder as opposed to involuntary manslaughter, this thing on a continuum. What's less than that? And what lies between involuntary manslaughter and third-degree murder? Well, in the cases we learn that a single punch, a single blow, is almost never going to be sufficient to show malice that takes us from involuntary manslaughter to third-degree murder. But we also learn that something more than a single blow could. So if you beat the person several times, particularly if you're larger, or if you are a particularly skilled fighter, then that can show the malice that we're talking about. Pointing a weapon at someone, whether you intend to pull the trigger or not, is enough to show the extreme recklessness that we assume for a malicious killing. So what you should have from this little template that I've given you is a way to go about thinking about not just third-degree murder, but any crime. Take a look at the statutory language. What can you learn from the language itself? Most often the language won't be conclusive for any given case. You'll then want to look at the precedential part of prior decisions. Most often that's just anything in a reported opinion. You're going to want to look at the definition of this particular crime as the courts have offered them to you. And in particular, you'll want to look at the interpretive gloss, the additional language that courts provide to flesh out the definition of the crime, any factors the court gives you in trying to determine whether this is that particular crime or not. And then finally, the examples. Look to examples and look to draw analogies to those examples to determine where on the spectrum, in the case of homicide, it falls, or in the case of something like burglary, whether you have committed this crime at all or not. So I hope this has been helpful. If you follow this template out, you should have a good way to think about methodically how to go about defining any particular